Finally. Okay. Start soon. Give me my 10-second delay. 10-second delay. Oh, great. So, a couple of things to note. First things first, for those that are doing the shoots and those that haven't done a shoot yet, the material from your first assessment only relates to the stuff from the first two lectures. So this stuff does not relate to your first piece of assessment, the 30% one on mistake and misrepresentation and misleading deceptive conduct. That's the first thing. Secondly, those shoots are going along quite slowly, and this stuff we're probably not going to put. This will appear in your shoot next week, but it'll be towards the end. We'll spend a decent chunk of that shoot time next year really on doing things that'll relate directly to your assessment. Okay, and does anybody have any questions about any of the stuff so far in the 12 minutes or so that it's taken me to get here and set up? Otherwise we'll kick off. So this, yeah. I'm not doing a very good job of it. Point forever. It's supposed to be my audience camera, but I haven't really done a very good job of it. Point at the ceiling, point at me, and then it's all broken anyway. It's kind of a moot point. It's either that or cats. Don't think that's going to work. But I just turn it off. Yeah, we'll just leave that. We'll leave that off. That's not a good look. No one wants to see up my nose. Thanks. Cheers. Cheers. Thanks. Okay. So, this lecture and the stuff from next week as well is to do with impaired? I say that wrong? Impaired consent. Duress is a common law doctrine. It's a vitiating factor, and it's one that we analyse in combination with a few other. That's why. How's this? Hang on. How about this? Is that a bit better? Or do you want me to? I'll put the two mics together. Okay. So the duress is really about reflecting the fact that we never truly can have a meeting of minds in a variety of circumstances. And the key thing to note is that contract law is not really at all about the substantive fairness of what is traded. Anybody that came to the last lecture of LA1106 will know that we gave Rachel a little framed peppercorn. Peppercorn. The reason for that is that peppercorn is sufficient consideration in contract law. The courts really don't care about the quality of your bargaining, and we know and understand that when people are coming together and negotiating contracts, there almost never is an equality of bargaining power. Have you ever tried negotiating the terms and conditions of your flight with Jetstar? Jetstar have very much a one negotiating step policy, which is, if you do not like our terms and conditions, fly Virgin. I went to carry 8.2 kilograms of luggage on the Jetstar flight, returning back from Melbourne on Sunday. And I had to then go, take everything out, put it under my tummy, like on my person. Despite the fact that I actually paid for a check-on bag. And I smiled sweetly and nodded, because what are you going to do? And appreciated, in conversation with the other passengers, that is the exact example. This entity is the one example we use in terms of this inequality of bargaining power. I have no power whatsoever in negotiating this. Now, an example of this, again taken to the extreme, is the South Australian Railways and Egan. This is the case. Went to the High Court, and it involved a contractor doing some work for the South Australian government. And this contract said, all right, you can come and do work for us, we'll pay you. But we don't like the work that you're doing. We don't think it's an appropriate amount of quality. We will reserve the right to terminate the contract. We will not pay you any money outstanding. we will take all of the equipment that you own, that you've left on site, and we will sue you for compensation. When this went to the High Court, Justice Menzies was reading through this, and his comments, I mean, it's a little sad when you were going through and read it, but he said this is the harshest, the most oppressive, the most unfair contract I've ever seen in my 60-odd years of judicial practice. It was outrageously unfair. Did the High Court overturn it? No. He signed it. He went into it with open eyes. And really that's what this is about. It's not about the quality of the bargain. It's really to do with the fairness of how it came about. It's not the substance. It's really the structure. And so duress is really to do with the physical act of overbearing someone's will, right? Making them do things that they don't really want to do. The other doctrine that we'll look at later on today is undue influence, which is kind of the same thing, but it's doing it not through overt threats, but doing it through usually emotions and feelings and family bonds, through that concept of overbearing someone's will, but in a less overt way. So the key thing to note here, though, at the start, is that duress is a common law doctrine, and undue influence is very much grounded in equity. Now, a couple of things to note about duress. Duress really involves threats, and we use this phrase illegitimate pressure. And there's some words that I think you guys may benefit from learning because they're used in the lay sense and they're almost always used wrong. Almost always, everywhere. And that is this difference and this distinction between unlawful, illegal, and criminal. That's unlawful, illegal, and criminal. Now, the latter of those, you guys probably should be able to have a pretty good handle about. Something is criminal with that it has some form of sanction and it's brought about by the state. Whether or not the sanction is large, getting a parking ticket, for example, getting fined through James Cook University, parking in here, as opposed to being charged for grievous bodily harm by the state. That's criminal behaviour. All right, and the key thing to note about things that are criminal, it's dealt with by the state. The state is outraged. The state of Queensland or the federal government of Australia is outraged. They are the ones bringing the action. Queensland or the Commonwealth. Okay. Now, things get murkier when you see the terms unlawful and illegal, and lay people don't usually know the difference, and to be honest, particularly the word illegal is mired in a fair amount of uncertainty in terms of what it means. In fact, we'll do a whole module on the legality aspect of contract law. But generally, illegal involves some form of quasi-criminal or regulatory offence as well. So doing things that are illegal generally have that aspect to it. That's not a hard and fast rule. It's not a clear definition. You don't find it being used in statutes. What you do find is the word that's used is unlawful. That is something which is contrary to law. Now, criminal acts are all contrary to law. That's easy. But what may not be apparent is that breaching a contract is unlawful. And that's an important consideration here. That this idea of doing things. And remember, contract law is strict liability. If you don't do what you promised to do, it doesn't matter if it's not your fault. You should never have signed up to that deal in the first place. So breaching contracts, most situations, is unlawful. Okay, so that term can come up. And the reason why I say that is that a variety of you guys, mature students, are going to be doing criminal law. You might be doing it now or you're possibly doing it next year. Where you'll see things like the excuse in Section 25 of our Criminal Code. And it says a person is not criminally responsible for doing something in an emergency. All right, what does that mean? It means they can still be sued and become liable in tort and in contract. So just make note of that distinction between the two. Everything that's criminal is also unlawful, but there are some things which seem on the face of it to be pretty mainstream. And one of those is breaching contracts. Okay. Now, duress as a doctrine is to do with pressure. It's to do with threats, overt or covert threats, to either the person, to that person's goods, or to a person's economic interests. Okay, and this key thing here is this word illegitimate, because in normal negotiations and contracts, especially between powerful parties, of course you're going to exert pressure on them. It's part of normal business practice. We want to get the best deal that we can, and we can pressure them. We can say, sign this or you're going to miss out. Sign this or we'll go to your competitor. Enter into this contract, or we'll go and on-sell this to someone else at a better price. That is legitimate. And that commercial behavior is legitimate. And in fact, oddly, duress is actually quite a new set of remedies in contract law. It's relatively recent. Certainly, economic duress is only from about the last 50 years. And the reason for that is something like this. It goes along with this idea that if you enter into a contract and somebody threatens you to do it, remember that threatening to break someone's kneecaps is still a tort, probably a crime, but we only care about the money. Think about tort. So that in theory, rather than having a separate doctrine where the courts say, okay, you can have the contract rescinded, undone, we'll just sue them in tort. Why does contract law need to get involved with this? Sure, someone threatened you and you entered into the contract, sure, and things went bad, but why don't you just claim for that damages in tort? And that was actually the prevailing attitude for a long time, for centuries. And they were sort of recognized by the 20th century, but that really doesn't work. Illegitimate pressure can be exerted in a wide variety of ways. And so an example of this universal sanctions of Monrovia and the International Transport Workers Federation. It's a union case, basically. There's a boat. It's flagged from Monrovia. I don't even know where Monrovia is. Anyone can feel free to enlighten me. And this boat was in port, and there was a dispute with the union for the ports. And the union said, we are not going to tug this boat out. It's going to stay here. We're going to keep it in port until you pay money into the union's workers' welfare fund. And so, as often happens with these sorts of matters, the parties need to achieve the particular result now. They need the boat to carry on to go and make more money. And so they talk about this idea of the irresistible force. Shipping companies like, these union guys, they want this money to go in their fund, but we need the boat, and we need the boat more. So we're going to give in to their demands, put the money into this account, get the boat out of there, and carry on our way. And then what happens afterwards, then we try and seek some form of remedy or some form of compensation, some sort of result after that. It often happens after the facts. Another example here is Hawker Pacific and helicopter charter. That case involved a charter company that needed to get their helicopters painted. And the helicopters got painted and the job was rubbish. And so they sent it back and said, oi, paint these again. Okay. So then things got painted again and the job was rubbish again. And so they sent them back and said, repaint this is rubbish. And before they'd gone back and got them for the third time, the charter company got a really lucrative contract. And these guys, Hawker Pacific, they found out about this, and they knew about it, that these guys had got this really profitable contract. So they said, oi, well, we have your helicopters here. We're worried you're not going to pay us or you're going to sue us. So we will only release this helicopter or these helicopters if you enter into this arrangement, this contract, excluding us from all liability. So saying you're going to pay and you're going to exclude yourself from all liability in relation to this. And so begrudgingly, the charter company entered into that arrangement and then afterwards went back and had a bit of a whinge to the court. And there, and in the tank ships case, the court said, look, this pressure that's placed upon these entities to enter into this contractual relationship, we do consider that to be illegitimate. That goes above and beyond merely negotiating in the ordinary sense to do with things. And the other point that I've got on there too is to do with the sole reason. Now, one of the elements of misrepresentation, remember, was to do with something that was material. It had to be material in terms of inducing someone into a contract. It didn't have to be the main reason, right? But it has to be it's a reasonably substantial one. So, for example, if there are 10 reasons for entering a contract and the fact that you were lied to, well, there's 5 reasons to enter a contract, and the fact that one of them you were lied to, that may or may not be enough, but certainly if it was 2 or 3, you could argue that those things, or that was material in terms of entering into it, and that would be sufficient. With duress, illegitimate pressure will vitiate the contract regardless. And that idea, and again, Crescendo Management and Westpac, in that situation, somebody was entering into a loan arrangement or debt, and they probably needed to enter into it anyway. They weren't doing very well. But illegitimate pressure was exerted on them as well. And there the court said that, look, in situations where this happens, if duress arises, it doesn't need to be material. It doesn't have to be the only reason for you to enter into the contract. It can be one of many. It's got a much lower bar than misrepresentation when you're trying to argue it. And that's really to do with, again, kind of the fairness of contracts and contract law generally. Okay, so there's 3 broad types of duress, and they involve, the obvious one is threats to a person. Hey, enter into this contract or we'll have your brother killed. And that can be, as it sounds, both threats to you, the person entering into the contract, or to family members or associates. Threats made broadly to third parties can still amount to duress. Okay? Assuming that the contracting party is aware of them. They have to have this aspect of notice. It could be constructive notice. Now, they ought to have been aware. They willfully and blindly put their head in the sand. That's going to be sufficient. But again, it really is just the most obvious case that threatening to do things to people, for them to enter into a contract. And again, Barton and Armstrong involved that. It's an Australian case, although that went to the Privy Council, involving threats where there was a contract, there was a business, 2 business associates, they needed to get some refinancing, and one person was going to sell to the other, and business wasn't going very good. All right, so you've got the situation where business wasn't going, and look, they were probably going to enter the contract anyway. Business wasn't going good, but there were also threats to kill the plaintiff. Might have been the respondent here. There were threats to kill that accompanied those, and there the court said, look, it doesn't have to be the main or even a dominant reason. If it's part and parcel of one of many reasons that you enter into contracts, it's going to vitiate it. You can go to the court and ask for a remedy. That one's pretty straightforward. Oh yay! There's a comment on the stream, on the chat. Thanks, Chloe. Okay, and again, that's pretty straightforward. I think that we understand in contract, threatening to break someone's kneecaps and whether enter a contract, you're going to be able to achieve some sort of remedy. These are common law remedies, by the way. The common law, so that self-help is available. Somebody threatens you, you go into a contract and you can see the goods and they're just over there. Once the threat is gone, just go and pick up your goods and take them away. You don't have to go and ask the court nicely for an equitable remedy. It's a common law remedy here. Threats to goods, again, pretty straightforward. They don't have to be yours. Can actually be third party. Of a party coerced. Not where I've written that there, that's actually not correct. The goods owned or controlled, it actually can be threats to third parties' goods as well. I'm not sure why. That slide I've made like 4 years ago too, and I've just noticed that now. That's a little embarrassing. Sorry? Yeah, it can be. You can have situations where it can be goods that actually belong to third parties as well. Because originally it was this doctrine came about the idea that look, if somebody's going to smash your stuff up, you just sue them in conversion. Why would you have to go through and have this this idea that you need to also vitiate a contract? Of course, not the destroyer of bargains. But as I said, in circumstances you can. It should also be third parties as well, because if you're smashing up somebody's, smashing up your family members' goods, can also be duress in a contract as well. So I wrote these. I did these slides like 4 years ago, and I've just noticed that now. Okay. Now, do you guys know what conversion is? I've just realized I'm using technical terms that I probably shouldn't. Has anyone here done Torts A? Torts A? Okay, sure, some of you guys would have. The grad students do it in their first semester. Conversion is a tort that is essentially trespass to goods. It's when somebody picks up, does something to your stuff. You have a right, things that you own, or have a right to immediately control or possess, you can sue people who do things to your goods. So if you have a helicopter and it doesn't get returned, let's detain you. If you have a car and somebody threatens to smash it up if you don't enter into a contract, that the smashing aspect, if they did go and smash it, that's conversion. So even if there was no contract, you could still sue somebody who smashes up your car. That's how that operates. There's some commentary to say that conversion is actually different and distinct from what they call trespass to goods in the broad sense, but the elements are essentially the same. It's direct interference with goods that belong to another. And the key word here that I mentioned at the start of the lecture is one word you need to note: unlawful. If some person comes up and they have a right, the police come up, police have a right with a warrant to enter into your premises. If people have a right to stuff, to do stuff, you can't be liable, not under this doctrine. It has to actually have some aspect of unlawfulness. Now, willful damage is a crime, and so that is going to be sufficient in this situation, but people who have an honest claim of right to things, honest and reasonably held claim of right, are not usually criminally responsible for going and essentially grabbing goods that they think, and they have to prove this to the court, that they honestly think belong to them. And so that can be, in that situation, it doesn't render it lawful, but just make note that's not criminal if people honestly think that stuff belongs to them and they come and grab it and take it away. But here, it's really to do with both threatening to break or damage things, threatening to transform them in some way, and in the case of Hawker Pacific, it's also threatening to withhold them. And the tricky thing there is that Hawker Pacific, in that particular case, and they had to argue this, have what's called a workman's lien, L-I-E-N. And that if you are doing work on a chattel, what's a chattel? Yeah, it's an item of personal property, something that can be picked up, physically moved around. It's not affixed to land. Fixtures are affixed to land. Chattels can be moved around and held and used and enjoyed. It's an item of personal property. If you are doing work on someone else's chattel, if you're a car mechanic and you're doing work on a car, you have a right at common law to withhold that thing until it's been paid for. So you notice this when you go to the mechanics. If they leave the car outside, what do? They disable it. They remove bits from that car to make sure you can't just wander in with a spare set of keys and just take it and zoom off. They have a right at common law to do that. Don't have a right to sell it, interestingly, but have a right to withhold it, possessory lien. And so that was what they're trying to argue here. The Hawke Pacific were trying to argue that we have a right to be paid. And so that was them trying to argue that what they were doing in withholding these goods was lawful, but they did not succeed. All right, the third one is a little bit vaguer because we have situations. Manna, yes?
Does it take like heaps of time for them to get the shoppers back?
It did take a long time. Basically, they paid. They got the helicopter back, signed the contract. Not sure whether they actually still paid the outstanding balance. I'm not sure on that one. But either way, they wanted to court at a much later date. They said that we want our money back. This was under duress. The other side said no. And so to resolve that, they had to go to court. And yeah, it was years later. It was years, I think it was near. Everything in the courts takes ages to go through and do. And that's why I think it's helpful to know this distinction between the common law and the equitable sort of remedies that you get. Because here, in situations where there is some sort of threat, and if you've entered into a contract and you know these rules, you know the rules of duress, and you've sold something at a low amount, leave the money aside, don't hand the money back, but just go and pick your stuff up. If the threat is abated, get your stuff back, then wait for the thing to go to court in that situation. Because look, to be honest, the bar is pretty low in terms of proving things, particularly when there are threats, particularly to the person. Where it gets tricky is threats to economic interests because of this, this inequality of bargaining power. And it's really important to note that just threatening somebody to not deal with them in the future, that's not illegitimate pressure. And when I did this subject as a student with Rachel a long time ago, one of my colleagues was also mature. She was about 10 years older than me, and it was a project manager. Big Len, there's a firm in Brisbane these days. Yeah, Len, if you ever hear this, shout out to your firm. And he said, as a project manager, this would happen in construction all the time. You call people up and call your subbies up and say, come and finish this piece of work, or we're going to tear up all of these other contracts. That is straight up duress. There's just no way around it. And he was somewhat horrified to find out that conduct is strictly unlawful. And so it's that. But that's different from saying, if you don't come and finish this, we're not going to deal with you again. That's different again. That can essentially just represent the inequality of the bargaining power between the two parties. And look, sometimes it can be blurry as a line as well. That can be a little tricky. And so here... So a
party's behaviour, even though you've got a future contract and a party's behaviour, you can't rescind future contracts.
If you choose to terminate future contracts, or you choose to not perform future contracts, that is unlawful. Strictly speaking, it's unlawful behaviour, and it can amount to illegitimate pressure within the meaning of common law duress. Okay, all right, and that's what happened with North Ocean Shipping. North Ocean Shipping and Hyundai. Hyundai is a big company. It's been a big company for a long time, and one of their arms of their business was boat building. They built boats, and they had a contract with this shipping company, North Ocean, and it was pegged to I think the Korean won and the US dollar, and and one of them plummeted in relation to the other by like 10%. It was going to really massively impact the value of the particular contract to get this particular boat. But again, this is what happens when people find out about stuff. Hyundai found out that North Ocean needed this boat because they had just received a really good charter. And so they said, sure, we'll go through and do this, but you have to sign this contract in order to offset this massive change in currency to our benefit. And so begrudgingly they entered into the contract, and there they said, look, in this situation, that went way above and beyond normal business negotiations. And in that situation, there was already a contract. So they were essentially saying, we're not going to perform our part of an existing contract. We're just going to breach. We just don't care. Unless you sign this new one, which gets rid of our obligations under the old one. And in that situation, that will count as a threat to the other parties, or illegitimate pressure towards the other party's economic interests. That can do it. It can be expressed in really, really broad terms. Okay, so these are the different ways that duress can come about, which is, I've sort of done this in a slightly back to front order, but when you actually rock up to court, you still have to go through and argue the elements. It's cause of action like any other. And so, just quickly go through those now. The key thing to note is this pressure. It has to have this illegitimate pressure. The first thing, pressure has to be placed on one party, and it has to somehow impair the true consent of the other party. Now, duress is a tricky one, and the way that it's described sort of by judges and commentators is that you know what you're doing when you enter into a contract that's under duress. You know what you're doing. You just find that there is an irresistible force that stops you from doing otherwise. You know what you're doing. You know this is bad, but there is irresistible pressure come to bear that makes you do it anyway. And that's a little bit different, if we think about it, from something like misrepresentation, where we didn't really have a true picture about what was happening. It's not that our will was overborne, we were lied to. We didn't have a true picture of it. And the same with mistake. We didn't truly understand what the lay of the land was, how this thing panned out. Here, we know what's happening. We can see the lay of the land, but some pressure has been exerted on us to sort of overbear our will, to sway us, bend our will towards this direction of entering into this contract. Those are essentially the two elements that need to be proved there. And a few things to note. Usually they talk about what illegitimate pressure is. I use the term unlawful, but it can also be unconscionable conduct. Now, it's possible you guys have been exposed to unconscionable conduct or unconscionable transactions in Amadio's case in your first semester of law, possibly. Does that sound familiar to anyone in this room? The commercial bank and Amadio? Okay, well, we'll go over it next week because we'll be going to do and talk about unconscionable transactions, things that go against good conscience. Usually in situations where there's some sort of special disadvantage and the other side acts not with full knowledge and uses or exploits that disadvantage. But it also counts if there are unlawful threats. And that can be criminal. All criminal acts are unlawful. But it can also be things that aren't in accordance to law, and that is things like breaching statutory duties, which is like a quasi-tort, committing torts, and breaching contracts. Those are all unlawful behaviour. So an example of that, and again from you guys that have done Torts A, would know that there are certain duties that are placed upon us by statute. We have a whole bunch of tortious duties. Tort of negligence, for example, places a duty upon us. We have a duty of care in certain circumstances when we're acting certain roles and when things arise on the facts. When we drive our car, we have a duty. For example, if we fall below that standard, harm can come. And if that happens, it's unlawful. It's a tort. We're committing a tort. People don't sort of appreciate that sometimes the law places duties upon you, and failing to achieve those things is actually unlawful. Contract is one of those. Breaching contracts is, strictly speaking, unlawful behaviour. Here, though, it's got to have a threat. Have a threat associated with it. That threat has to go above and beyond what normal commercial operations are. And so that's Smith and William Charlick. It is a high court case, but it involved the I think South Australian board for, it was either wheat or it might have been dairy. One of those, I can't remember. It's one of the two commodities where they had a single, we call a monopsony, single buyer, and this guy was a farmer. I think he was a farmer, and he was selling to them. I think that's how that arrangement goes. But the key thing to note there is that there was a great inequality of bargaining power, great inequality, and the entity, this William Charlick, said, "Oh, we're not going to deal with you unless you make a voluntary contribution to like one of our welfare funds for our union people," similar to the tank ships case, actually. If you just make a donation to this third party, if you don't do that, we're not going to deal with you. And then the court said, look, that's actually not illegitimate pressure. It's not. It's actually, this is the thing that can happen in business from time to time. There are power dynamics. You are the weaker party. If you do not want to do this thing, even in situations where they are the only buyer, you do not have to contract with them. And remember, this is, the 1920s, so this is before statutory regimes and the strong sort of unfair terms regimes and stuff in the Australian consumer and things like that. Trade practices rules came into place. And there they said, but look, in that situation, it's too bad. If you don't want to deal with them, don't pay the money. It's not going to be illegitimate pressure as far as contractual duress counts.
Is it still duress if you're going to enter into a company for several contracts, say it's a cleaning contract or something like that? Mm-hmm. You've got a really dodgy gas and you want to clean, it's absolutely shocking.
Yeah.
And you say, take this shocking contract and we'll give you 50 future ones to make up for it.
Well, doing that, remember, that arrangement, as you've described, kind of sounds like a contract in itself. If you do this, and we'll appreciate that threatening to breach contracts with third parties is unlawful, so that often those contracts won't be enforced by the courts anyway. But choosing to enter into arrangements with parties under the proviso, if you do this, that if they do this for you, then you'll enter into all these other ones. That's a collateral contract. That's something that is a little contract in itself. Your consideration you're offering is to enter into all of these other ones as a result. And this is capable of being analysed on its own. And that's okay for the entering into stuff. Doing it for breaching contracts, if we entered into this one, I'll breach all of these contracts with our competitors. That's going to be problematic in terms of enforcing that in the courts. That idea of going.
Because it's a promise, like do this job right now, and it all falls to bits. They don't clean the house properly,
Yep.
they don't that one, but they've got the promise of future business.
Yeah.
Is that
Threat. So in other words, they're threatening, telling people to come and fix this house now in order to.
Yeah, I'm just thinking about it going
Yeah.
the other way, rather than threatening that you're going to cancel and giving them an expression to get into a bad contract.
Okay, I see what you mean. Well, and again, that it depends whether or not you've promised to enter into the future ones. Because if they enter into a bad one and they're doing it with open eyes, here's the contract, you're going to lose a lot of money on it. If you enter into that, we've got all these future ones that we will enter into at some stage. And again, if that representation, this is really where things like misrepresentations and things come into it, but if it's, so it could either be a misrepresentation or it could be a collateral contract. You will do this, and the consideration that we offer is that we will, if you enter into this bad one, we will do all these other ones as well in relation to that. So all those things would probably fall under performance and breach rather than under here, I wouldn't think. Okay, this duress though is about consent. It's not about the knowledge of the parties. The people are going into this with open eyes, but they just don't truly want to. They don't truly want to go through and enter into these things. And they talk about this idea of the will isn't, strictly speaking, overborne. You're still, voluntarily going into a contract. It's part of the nature of the way contract law works. But things are twisted. Your will is deflected towards the, essentially bent towards the person who wants you to come into this contract. That is what irresistible pressure is, where they cannot give true consent. How do you work that out? You look at these things here. Did the plaintiff have a whinge about it? Did they have any other way out? Because if you could have just, if the threats were, go and do this, this, and this, but there's no consequences if you go and do that instead. Well, why didn't you do that instead? Whether or not independent third-party advice was sought in relation to such things, and delay. All right, delay is a tricky one. In fact, that North Ocean shipping, in that situation, the courts did say, look, yeah, sure, this would be duress. Yes. Are we going to give you a remedy? No. Why? Because you took way too long. So that idea of, as I mentioned before, it's quite common, like Hawker Pacific, here's the helicopters, we need them now. Trot away, use our helicopters, then go back and sue and try and get the contract vitiated. If you take, and I think these guys took 10 months, I think, before raising it in the courts. It's too long. It's too long. Clearly, this demonstrates that your consent wasn't impaired if you're going to take this length of time. If you're going to take too long, you're not going to get up. Okay, so what happens? What happens with these cases here? There's ACCC and Davis and Kapalabla. They are cases actually under the statutory framework, which I'll do after we finish this. I've only got one more slide. But make note that, like a lot of these vitiating factors, there's a tort that you can argue at the same time. So if you're going through and you've got a common law action in duress, you also run this corollary tort, and because the thing is with tort is you get damages in tort, whereas the default rule with duress is you get this right to undo the contract. I mean, why you wouldn't want to use that right? I mean, why would you bother going to court if you weren't going to want to undo it? But you, nonetheless, even though you do get that right, you can trot off to court and do that. And the courts can sometimes say, nah, you took too long. And that's what happened in Great Ocean shipping and Hyundai. If you take too long, or with this restitution in integrum, if we can't undo the contract, maybe the subject matter has been destroyed, maybe it's passed on to a third party for value. And in other situations, maybe you've taken all of the steps and demonstrated to the world that you've actually confirmed that this contract is okay. If you didn't jump up and get angry about it at the first moment that you could, then you're really just affirming it, ratifying this arrangement that the parties had. And those things are going to make it impossible for you to seek a remedy in common law duress. But assuming that you do, you can still get damages in where it is. In the corresponding tort, which is intimidation. And there's two ways that you can do this tort. That first one is to do with proving that somebody unlawfully threatened. It's actually expressed in more broad terms than simply the common law duress as a vitiating factor. So you can actually argue this torts in situations where you suffer some loss independent of a contract, because this is a tort. Torts they have broad application. In situations where you've suffered, where you've managed to prove that there is duress in that situation, where something is unlawful and arguably unconscionable as well, in those situations, because that, as a result, it's caused you to act in your own loss, in this case, enter into a contract, that's one way you can argue this first type. The second type is when things involve third parties. And if people go and threaten third parties, your family members and so on, to do things, then you can, and this, as a result, causes you to suffer some sort of loss, you can seek compensation for that loss. These things don't come up much outside of arguing or being argued alongside actions of duress. And you might recall that when you're trotting off to court in regards to things like vitiating factors of contract law, usually you fire a shotgun, not a sniper rifle. They'll try all and sundry. And it's something I've certainly found in my limited legal practice, that when you're heading these things up and doing pleadings and making arguments that you could rot off to court, usually you'll find that some are much stronger and they get weaker and weaker and weaker. And when by the time you come to do something on the tort of intimidation, I mean, if I was doing community legal and my time was literally worthless, then sure, why not? We'll put it in there. I think in terms of commercial practice, you'd probably try and stick to the big ones, particularly things under the Australian consumer law. It's better use of most of your time. Okay, what I'm going to do now, we're going to take a break. I'm going to end this particular stream, and we'll come back and talk about the next component, which is the statutory stuff.